On the 14th of February 1995, South Africa's first democratically elected president oversaw the inauguration of the Constitutional Court, which would be representative of the fabric of society. The late President Nelson Mandela opened the doors to the Constitutional Court as the country beamed with hope of a better tomorrow that would close the doors on injustice, inequality, and determine the meaning of the Constitution against the backdrop of the country's dark past on many spheres.
This historic occasion marks the beginning of a new legal order in our country. It is a legal order that derives from the Constitution of 1993, making the Constitution the supreme law of the land, binding on all legislative, executive, and judicial organs of state at all levels of government. A legal order committed to the creation of an open and democratic society based on freedom and equality.
The founding justices, adorned in the specially designed green robes, took their seats and oaths to protect the Constitution and the fundamental human rights entrenched therein. These included former President of the Constitutional Court, Arthur Chaskalson, as well as who would later become Chief Justice Pius Langa. The Constitutional Court would go on to deliver a number of landmark judgments that informed the constitutional democratic order. Its first hearing dealt with the death penalty and established that capital punishment was inconsistent with the commitment to human rights expressed in the Constitution. The constitutional rights of prisoners were affirmed in the 1999 case of August versus the IEC, as well as the National Coalition for Gay and Lesbian Equality versus the Minister of Justice, which saw the unanimous striking down of the criminal prohibition on sodomy between consenting adult males.
The court says that we have a right to equality, to dignity and to privacy, and for all of us this is a day in which we will celebrate and in which every person in South Africa, irrespective of sexual orientation, heterosexual people and all of us have to echo what the Constitutional Court says, and that is equality delayed is equality denied.
Despite this glowing legacy, the current day does not see candidates availing themselves in spades to serve in this court, which plays a significant role in the country. In October 2023, Chief Justice Raymond Zondo revived the practice of bringing law professors and lawyers to act in the ConCourt. Despite what seemingly appeared to be an intervention, sufficient candidates are not being secured.
It is very worrying that even after the intervention that was made last year, we were not able to attract sufficient candidates, and we have had to re-advertise.
Prompting the question, why does a court which holds such a rich legacy and prestige in the country's democracy fail to attract candidates 30 years into democracy? Outgoing Chief Justice Zondo cited a number of possible reasons, such as the remuneration of justices, as well as the experience garnered by judges in the high courts.
One of the things I've heard in interviews of the JSC is that many judges in the High Court do not get much exposure to constitutional cases. I've asked them quite a number of times, and many say the exposure to constitutional work in the High Court is not very good. And it may be that because of that, there is some reluctance on the part of many judges of the High Court to make themselves available for appointment to the Constitutional Court.
Nominations for the re-advertised vacancy at the Constitutional Court must reach the Secretariat of the JSC by no later than the 30th of August 2024, which will also mark the end of Chief Justice Zondo's tenure as the head of South Africa's judiciary. Canny Maphanga, SABC News, Johannesburg.